One of your employees tells you they need a reasonable accommodation. What is a reasonable accommodation, you ask? And do I have to give it to them? I'm Alex Rubin, owner of Rubin Employment Law, and an employer who also deals with these issues. In this video, I'm going to give you a basic roadmap of the law around reasonable accommodations. First, what is a reasonable accommodation? It's a change to the employee's job duties or working environment that allows them to perform the essential functions of the job without causing an undue hardship to the company. An employee with a disability or medical condition may request a reasonable accommodation to be able to continue to perform their job. The employer is required to engage in what's called an interactive dialogue to determine whether the accommodation requested or a different one that meets the employee's needs can be provided without causing an undue hardship to the company. Examples include providing more frequent breaks, a shortened work week, a stool to sit on instead of having to stand all day, light duty, work from home, or even an extension of a leave of absence. Look, you do not have to provide every accommodation your employer requests. There are two tests to apply. Number one, can the employee still perform the essential functions of the job with the accommodation? For example, a cashier or a waiter cannot work from home, but a computer programmer can. Number two, will the accommodation cause an undue hardship to the company? For example, is your employee requesting expensive equipment to be able to perform their job? How expensive is expensive will be determined by the size of the company and its revenues. Or is the employee requesting to be assigned to a completely different position for which you do not have any openings or for which they are not qualified? You are not required to make such an unreasonable accommodation. We know that navigating these issues can be tricky, so if you need help, give us a call.